Hi everybody, today's video lecture is going to focus on another part of the First Amendment, specifically freedom of expression. Freedom of expression is the right to express yourself through written, spoken, or active expressions of thoughts and opinions. With the freedom of expression, the overarching idea is that you can believe whatever you want. The First Amendment prohibits government from limiting your freedom of expression, but it is not without restrictions. Is this freedom absolute? No. And it's up to the government to identify what is or is not permissible to express in public. And through various test cases, the court has had to step in and decide that there are certain forms of speech that are permissible and some that are not, and that there are certain restrictions on what you are able to say through spoken expression or write through print. Today, most forms of speech are permissible, but the Supreme Court has decided that certain types are impermissible. Now, there are two main components of the freedom of expression: freedom of speech and freedom of press. Both have roughly the same protective standards for rights. We can also add freedom of petition and assembly into this as well. The question really becomes, though, when does one person's right to free expression violate others' right to peace, safety, or decency? Now, when it comes to freedom of speech specifically, there are three types of speech: pure speech, speech plus, so speech involving words and action, and then symbolic speech, where your expression is coming through no spoken verbal language, but through some type of action. And it could be an array of expressions: actual words, lack of words, pictures, actions, etc. For the most part, pure speech, purely spoken word, has our strongest level of protection through the Supreme Court. Speech plus, so that words and actions together, is kind of that middle ground. And symbolic speech, this is what has some protection, but a lot of times these actions go beyond the limits of what the Supreme Court is comfortable protecting. So first, we'll talk a little bit about the weighing of free speech and public order. One of the things that the Supreme Court has put kind of an exception on with free speech is that it sometimes is necessary, especially in a wartime, for government to limit and restrict speech in the name of national security to preserve public order. So some permissible restrictions here would be a protection in terms of national security, where if you speaking against something might jeopardize the government's objectives in terms of national security. The freedom of speech was really included initially to protect your right to criticize the government, to be free from government censorship. However, there are instances where the government has said that speech may pose a clear and present danger. So we have something called the clear and present danger standard, where if the speech poses a threat to society, the government can curb it. And this is kind of a question that's important to answer. Is the speech dangerous, or is it merely inconvenient? What does danger actually mean? And this has come up with questions even recently about hate speech. Is hate speech protected speech? And the court has said that unless it's directly intended to incite violence and action that is lawless, hateful rhetoric is protected. It's not protected when it accompanies the action piece, but it is protected in public places. You can protest, you can march, there can be a parade for any type of cause. It just can't invade on somebody's private property. Now, one of the required SCOTUS cases that we'll be looking at that addresses this is the case of Schenck versus the United States, that really dove into this question of what type of speech could be limited during war. And this is the case that establishes the clear and present danger standard and asks that question: is the speech dangerous or merely inconvenient? And we'll examine the looks at the facts of that case in a couple days. Now, when it comes to freedom of the press, there is very strong protection for the press, for the media, against government censorship. And we call this prior restraint. Prior restraint is another term for censorship. So essentially, when the government forbids the publication of material in advance rather than ruling on illegality afterward, we call that censorship, where they're forbidding the publication of material. So you have to allow the press to publish things, unless, again, it could have some national security implications. A case in 1931, the case of Neer versus Minnesota, is where prior restraint was ruled unconstitutional. In this instance, Neer published an article attacking local government officials, claiming that they were gangsters. Minnesota government officials got an injunction to prevent this article from being published. We called this a gag rule, where essentially you were forced to stop before you could publish the information, and the court ultimately decided in this case that that gag order to not publish that information violated the First Amendment. The freedom of press does not apply to students. Schools can regulate what is printed, what is published. Here again, though, there might be an exception made if there is, a wartime measure in place, or if national security is at stake. So for instance, we don't want a paper publishing the details of an upcoming military operation, and that might jeopardize the success of that. Now, symbolic speech then is that not necessarily spoken speech, right? This is speech that has some protection, but oftentimes can go beyond the limits. So with this symbolic speech, we have actions that express an opinion, some protected by the First Amendment, but not all. Some examples of symbolic speech would be wearing an armband in protest of something, burning the American flag in protest, marching in a parade. But the question is, what can the government say is not protected symbolic speech? Not all things are. There are some limitations. So again, not an absolute protection. Things the government has said, the Supreme Court has ruled, are not acceptable symbolic speech: burning draft cards, threats, intimidation. But the question that the Supreme Court has to weigh is the government regulating the message or the conduct? And it has to be more the conduct than the message being regulated. Texas versus Johnson is actually a case where the Supreme Court said burning the American flag in protest is constitutionally accepted under the First Amendment. A case that looked at symbolic speech for students, going back to the example of wearing an armband, is the case of Tinker versus Des Moines, where students in the Des Moines School District were wearing black armbands in protest of the Vietnam War. And the school district said they couldn't. These students took their case all the way to the Supreme Court. Here again, we have a required Supreme Court case that you will take a closer look at in the coming days. Other restrictions on freedom of speech. So as we've said, this is not an all-inclusive right. There are going to be restrictions placed upon it. One thing that the Supreme Court has consistently not said is protected speech is obscenity. And obscenity would be language, images, etc., that are lewd and offensive. The question is, though, what exactly is obscene? How do you determine obscenity? It's hard to define. It's still not clearly defined, and it can be something that ebbs and flows based on societal standards and evolving changes there. But Roth versus the United States made it clear that obscenity is not constitutionally protected. And essentially the court said it's up to society to define what is obscene and what's not. So it should be really based on what do most people at the time in an area find offensive. And this was about mailing obscene materials through the mail and the test there. Miller versus California, this was another one. Are you able to distribute obscene materials or give out obscene materials? And so this was trying to clarify further what exactly is offensive and obscene material. And so this basically said that obscenity, you kind of know it when you see it. It's offensive. It lacks serious artistic value, but that again, it should really be up to juries of your average people to decide what is or is not obscene. One of the things that there is consensus on, though, is regulating adult content. Most people can agree that we don't want all obscene materials to be banned, but we want it to be regulated. We want it to be open to consenting adults, banned for minors, but that has become harder and harder to regulate now with new technology. Freedom of the press, some restrictions here, what you can and cannot say. So one of the things that's not protected is defamation. Defamation is malicious or false statements that damage a person's reputation. This is not protected speech. So libel would be written lies and false statements, slander, spoken lies and false statements. But unfortunately, the standards of conviction for defamation are very, very high. A lot of awful things can be printed or said before it counts as libel. So courts often allow for a very high level of defamation before awarding a suing party some type of retribution. So it's often prosecuted, but it's really hard to convict. And for public figures, it's even more difficult. So for instance, politicians, celebrities, they kind of put themselves out there into the public. So even if you are knowingly publishing things, if you just come out and say, well, we didn't know it was untrue, we didn't mean to cause harm, then oftentimes you're ruled against, because it has to be proven that it was intentionally malicious behavior to cause harm. So statements about public figures are only libelous if the speaker knew it was untrue and said with the intent to cause harm to the person. And so malicious intent is very hard to prove. For private individuals, the standard is lower, but the victim needs to have a pretty high burden of proof that the defamation was false. Finally, looking at the right to assemble and associate, this would be kind of gathering to make a statement via the First Amendment. It's permissible. There are, however, a few restrictions, so allowed again, but not absolute. You can't prohibit a gathering, a protest parade, but laws can limit the time and place of a gathering. You may need a permit from your local government or whoever it is to make sure it doesn't conflict with public order. But no matter the content, you have a right to protest and assemble, as long as you are doing it with any time, any place, not on public property, or you have to be on public property, not on somebody's private property. Sometimes there's regulations how far away you have to be from other buildings, but you have the right as long as you are not harassing other people. And of course, you have a right to associate with people who share a common interest to you. All right, that is the end of our video lecture. Lots of stuff to unpack there. Review those notes. If you had a question while you watched, be ready to answer them and ask them tomorrow, and come ready to apply what you've learned in class, because we're going to put the freedom of expression to the test.